I mean, I cannot stress enough. If you have been declared incompetent to stand trial, that's not just like your mild crazies. Like, that's not even like moderate crazy. You're crazy. Like, that's the kind of person, like, yeah, they're going to hold you in a mental health facility because you are like, you are nuts. We're the Armed Attorneys. Today we're talking about your right to a speedy trial. We're going to talk about the Sixth Amendment, what the Supreme Court has said about it, and why your rights are just constantly violated. But before we get started, show your support for the Second Amendment by hitting the like button.
And check your subscription status, notifications, all the good stuff, because we have seen YouTube has been a bad boy.
Yeah, and I mean, speedy trial is important, and it's come up, I mean, locally in Harris County, there was a guy, we're going to talk about him, he was in jail for 18 years awaiting trial. It's come up in our office recently, but also in part, like, YouTube is like basically deplatforming gun content everywhere right now, and that very much affects us and includes us, even though we just talk about stuff. We don't even show you guns on this channel, but anyway, we're probably going to do a couple more of these and see if we can build our, momentum back up a little bit, because it's interesting. It's your rights. It affects self-defenders, and then hopefully they'll start showing people our videos again, and then we can do more gun stuff.
We get back to the stuff that we enjoy talking about, but this is really important because you hear about this come up. I mean, I can't tell you, I've never had a client say, "Woohoo, this got resolved so speedily." I'm very happy with how the process worked.
No, almost never. And then the ones that you do get resolved really quickly, they're almost never grateful.
Well, Chase had that dismissal on his first setting. That was maybe a week ago.
Yeah,
I don't think that guy was even happy.
No. All mine get dismissed on a first setting because they're all banditos like that. They're all bikers, and they're like, basically like,
they're gonna honor guard you down here.
They're gonna honor guard me because I didn't get an apology letter from the court.
So. Let's start with the Sixth Amendment to the United States Constitution, and this deals with speedy trial, and it's kind of the backbone of this entire discussion.
Yeah.
So we'll start here. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of his accusation, to be confronted with the witnesses against him, and to have compulsory process of obtaining witnesses in his favor, and to have assistance of counsel in his defense. So we see that as, obviously the founders thought this was really important. They put that in the first sentence.
Right. And like everyone, and people say this about the Second Amendment all the time, where they're like, can't you idiot lawyers read? It's clear as a bell. And it's like, no, it's not, because every single one of these clauses has been litigated fully up to the Supreme Court.
Between each comma, there's probably an entire book on it.
Yes. I mean, there just is, and I get it. You read these things and you're like, I understand what they were going for.
Yep.
Sure. But the law has to be applied consistently, and the only way we get the law applied consistently is to litigate these things and to create balancing tests like we've done here and get the Supreme Court to rule on it. So every single one of these clauses is fully litigated, including your right to a speedy trial. Because think about it, what does speedy mean? And speedy might mean something different in Houston, Texas than it does in Cheyenne, Wyoming, and in New York, New York. And so we have to have litigated this all the way up to the top so that we have a way to consistently apply the law.
Yeah, spoiler alert, speedy doesn't mean speedy.
Yeah, no, what we have found is that speedy trial is totally meaningless. So we have our, I would say this is probably our seminal case.
Yeah.
It's called Barker versus Wingo. It's a Supreme Court case, in case you're interested. It's 407 U.S. 514. It was decided in 1972. And much like every speedy trial case, his right to a speedy trial was, in fact, denied. And the Supreme Court affirmed that it was okay that he did not get a speedy trial. But they set out the balancing test. So Mr. Barker was accused of the crime of murder. He sat around waiting for his trial for about 5.5 years, and he waited that long because the government was like, aha, we don't think we can get him convicted without the testimony of his accomplice. And so we're going to try his accomplice first, because once his accomplice is convicted, he'll roll over. He doesn't have anything to fight for anymore. So we got to do that. So this poor guy is just sitting around waiting for his accomplice to be retried like 6 times.
Yeah.
It was like totally ridiculous. And here we go. He finally says, look, I need a speedy trial. And the Supreme Court says, hold on a second. So they lay out for the first time the balancing test, which the Supreme Court loves. What factors do we look at to see if your speedy trial right has been violated?
So obviously we have to look at the length of delay, the reason behind the delay. Did the defendant, the person accused of committing a crime here, did they assert their right to a speedy trial, and have they kind of been harmed or prejudiced? And unlike, other rights, we think when the government illegally obtains evidence, all right, we got a clear remedy here. This evidence is going to be excluded. Or if you that led you to the discovery of, other evidence. Well, we call that fruit of the poisonous tree. We're going to exclude that stuff. Think about different kind of rights here. How do we assert a speedy trial right? All right, it's not necessarily clear because it doesn't really fit into one of these other kind of categories where it's like, all right, your right was violated. We can find some kind of judicial remedy, and the court doesn't give us a lot of help in that instance, but it's we do get some clarification eventually.
Yeah, and they actually go through and they distinguish, and this is part of the reason why your speedy trial right can get violated all day long, is because they actually explicitly say in this case, hey, your right to a speedy trial is kind of different. It's different than lots of your other constitutional rights in that it does not per se harm you. And I mean, we see this in our practice too. The time is often the friend of the defendant.
Yeah, it's cases, I'll just say, general note, the longer a criminal case goes on, typically the better it gets for the defendant.
Yeah.
Memories fade, passions kind of calm down, witnesses go missing, police officers
Evidence get mishandled.
Yeah, you have your cocaine rats eating up the drugs. There's all police officers get disciplined, change departments. I mean, all these good things happen, and those usually favor the defendant.
Right, but so because of that, they're like, look, it's not like someone like torturing you until you give a confession, which is obviously going to be harmful to you. It's not like you getting denied a right to an attorney. That's obviously going to be harmful on its face every time. It's something that maybe hurts you, right? Which I'm not sure that I agree in theory, right? But so they've set it up for it to be a disfavored right, essentially, which is exactly what happens, because now we've got these 4 factors and they just get nitpicked. It's like, well, how long was it? When did you assert your speedy trial right? Whose fault were the delays? There's just, and like, are you really that hurt? Are you really that hurt? Because if you're not in jail, are you really that hurt? And that's the part that really...
Yeah, it drives me bananas.
In looking at the case law, that's the part that's really upsetting, is that it's like, for most of my clients, that harm ends up being you are like having panic attacks constantly because you're going to be on trial for murder.
You lose your job.
Yeah. And that's the sort of thing that the courts are all kind of like, well, like, did like the witness who was going to testify for you die? Because that's harm. But all that other stuff you're talking about, you're not really harmed by this, which is just ridiculous. But that's what the Supreme Court has set up in this Barker case.
Yeah. And so, we look at, and maybe this is where we can insert a little bit of gun law right here, because I see this happening with other rights in the Bill of Rights. New York State Rifle and Pistol Association v. Bruin. Look at the text of the Second Amendment. Maybe we looked at the text of the Sixth Amendment. It's informed by history and tradition. We're not going to do these kind of balancing, strict scrutiny, all these other things that the court likes to invent. What did speedy trial mean at the time of the adoption of the Sixth Amendment? I would like to know what that means.
I would like to know that too.
I bet it's faster than 18 years or 5 years.
But it is. You know who doesn't care anything about that though? Literally any court.
That's true.
But no, that would be fascinating. I mean, because I do think that is highly informative, but no one cares. I haven't read anything about it.
Yeah, but we do get some clarification. This is in 1973. This is the Strunk v. United States case, 412 U.S. 434. And that's where they say, all right, the remedy, if your speedy trial rights have been violated, the remedy for this is a dismissal.
Right, which is good, because we had courts doing weird stuff with like, oh, well, yeah, you were violated, but we're just going to take that time off your prison sentence, which, like, that's not right. So, yes, so that's good. We've got Vermont versus Brilliant. That's 556 U.S. 81. That was 2009. Says your defense attorney delays can't prejudice the defendant. And then the last word that I can find on this happened in 2016 from the Supreme Court.
Yeah, and so this was Betterman v. Montana, 578 U.S. 437, 2016. And so your speedy trial right, they say that ends at the time of conviction. So, let's say, and this happens, court, judges, they're supposed to be the umpire calling balls and strikes. Well, sometimes they screw up. It causes harm, and it would cause your case to be overturned or reversed, or maybe you need to get retried. But, that's all happening on appeal. Speedy trial does not come into play when we're looking at appeals.
No. And that plays into something, this didn't come from this case, but that plays into something that's also within the case law, which is that your speedy trial doesn't start until you get indicted. So if you have to shoot someone and kill them in self-defense, and then 10 years later they indict you for murder, the clock didn't start running when you had to defend yourself. The clock starts running when you get indicted, and the clock stops running when you get convicted at trial. So it's a pretty short window of just in terms of like the general timeline from incident to end of criminal prosecution. And that's like the federal case law. In Texas, if you don't file a speedy trial motion, they're like, sorry. And if you do, it didn't start till you filed it.
Right. So, and typically a court is going to completely blow you off. I mean, let's say an average criminal case takes 12 months to, 18 months to resolve. Mm-hmm. If you file a speedy trial motion within that window, I mean, it's getting denied, obviously. Yes. But, I mean, the court's going to find your attorney very unreasonable.
Right. But that's the thing, is that, like, people are like, well, so what? File it immediately. It'll get denied. Yeah. But then the other weird thing is you start blowing credibility with the court. And that's a weird dance for lawyers, because it's like...
It's hard to explain to clients, too.
It's hard to explain to clients that, like, you don't see lawyers doing this. And so if you're the one guy who's like, we've been here 3 months, speedy trial motion, the judge is going to be like, what kind of like stupid idiot are you? And that's tough, right? Because you never want something like that to color then what later happens in trial, color how that judge is going to treat you. So you have to balance like what is like kind of reasonable under like everything else that's going on here versus like, okay, and you don't know when you're going to need to, like 3 months into the case, you don't know that you need to start the clock on speedy trial. You have no idea yet if it's going to be a really bad, unreasonable time between that mark and trial or not, right?
Yeah. And so what do you do? I mean, let's say you're charged with a crime, you're languishing here, I mean, yes, at some point you should be filing a speedy trial motion. I mean, you want to invoke those rights and those protections if you have them. Just as a practical matter, it just stinks, and we hate to be the bearers of bad news. Courts just don't take this stuff serious.
No, it's going to get denied. Every single time your speedy trial is going to get denied. And if it doesn't, the appellate court's going to come in and reverse it and say, no, that wasn't a speedy trial violation, which is just outrageous. But that sort of brings us to what's happening in current events in Harris County.
Yeah, and this is what kind of brought all this up.
Yeah, so we have a guy who was accused of, not we, but out there in the ether in Harris County, there is a guy accused of a murder of actually like a Joel Osteen family member, which is a weird sort of thing. But this happened in 2006. He just got released, never went to trial, just got released from the jail this year.
They dismissed his case.
So 18 years.
Yeah, well, I mean,
they got one of your murders. They got you for 18 years.
Well, and Kanye. Yeah, and a lot of this,
I don't support Kanye.
Did he file his speedy trial motions?
No, but arguably, maybe.
So
okay, it's a weird thing. You start telling him.
Well, okay, so I mean, we have a lot of different clock stoppages through this 18 years. He was once at one point in time declared incompetent. That means basically you can't effectively assist in your defense. Sent for, I want to say, almost a decade to regain competency, so clock stopped during all that. That doesn't count towards speedy trial. Yeah, I mean, there's some other clock stoppages. Yeah,
so, I mean, he doesn't get indicted till 2007, so clock doesn't start till then. It's a capital murder, so, I mean, he is sitting in, I mean, he's not going anywhere. Right. So that would weigh like, oh, well, you're sitting in jail. You have a better shot at getting a speedy trial granted because there's prejudice there. You can't go out and talk to witnesses on your own or try to assist your attorney in your defense. Not that we generally want you talking to witnesses, but that's one of the things the courts kind of throw out there for some reason. But yeah, he gets found incompetent in 2009, which is already like 2+ years after indictment.
Yep.
And then competency, right? You go to the mental health facilities, you come back every once in a while, they evaluate you again. Now he's out there in the ether now telling everyone, like, I was never incompetent, but like, it is not easy to be found incompetent. So something was going on, right? But his competency isn't restored till 2024. So it's like, in that time, and it sounds really egregious, but what are you supposed to do?
Yeah. Sidebar. Have you ever seen, I haven't had this happen to a client, but I've seen this happen to folks. And I think there's some proposed legislation to fix this, but folks will regain competency and then they'll sit and wait for several months to be sent back to the court. When they get there, guess what? They've lost competency. And so then they just get put in this like death spiral of incompetent, then waiting, then losing competency. And so, I mean,
Yeah.
I wouldn't be surprised if that happened.
Right. But then it's like, but what, like, and just practically speaking, what do you do? Because you can't try someone who's not competent,
Right.
but you also can't release them into the public because, I mean, I cannot stress enough. If you have been declared incompetent to stand trial, that's not just like your mild crazies. Like, that's not even like moderate crazy. You're crazy. Like, that's the kind of person, like, yeah, they're going to hold you in a mental health facility because you are like, you are nuts. You are probably at least a danger to yourself, probably to others, because it is a high standard. Now, he does write some interesting letters to the judge.
Maybe invoking speedy trial.
Maybe invoking speedy trial, because he's like, I'm just sitting here and I'm not crazy. The cabal's out to get me, but I'm not crazy. So like, I don't know. But anyway, that 18 years, I mean, that is, the news, I think, is splashing out to be something a little bit more egregious than it. Not that any legacy news outlet ever in the history of time has ever done that.
Innocent man sits in jail 18 years. Emily Taylor. That's not egregious. I'm just kidding.
But yeah, but still, but I mean, you can see, I mean, like, this speedy trial, why wasn't, right? Why didn't speedy trial apply to this guy? Well, that's why. The competency issue, and it was never asserted due to the competency issue. And had it been asserted, I mean, I could, at 18 years, of course, probably like, I don't know. I mean,
I would hope a court would dismiss the case.
but not if you're incompetent.
No.
Yeah.
But
So, I mean, yeah, I mean, it's just, what do you do? It's wild.
yeah. So, but you see, you know, this is one of those things. Hey, we're not a huge fan of these disfavored rights. You know, I saw some stuff about, hey, they wanted people to be indicted and tried within 30 days. Like, this is some old
Oh,
stuff.
yeah. And that's not okay either.
Right.
'Cause you can't get ready.
Right. But, you know, there has to be some reasonable solution to this. But we hope you enjoy this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please, always question and comment for us below. Until next time, we're the Armstrongs.